They said that even if you didn't believe in traditional religion, even if you weren't a believer in God, that the role of conscience in their lives had fulfilled the same place as the traditional belief in God. They were exempt. Okay? So now we see conscience is disassociated with religion. That you can have a conscientious objector who was not religious. That would have been unheard of. And I'm not saying that's wrong, but that would have been unheard of at the time of the American Constitution, because people just assumed you couldn't be conscientious if you didn't believe in God, and people who didn't believe in God had no consciences and they were a danger to society. That's not quite true. You know, some people don't believe in God, period. Okay, now, so therefore you got the distinction between religion and conscience. Now we're going to have another distinction. Fast forward again to 1990. To a case called the Smith case, famous case, decided by Justice Scalia. The case involved two Native Americans from Oregon who asserted their right under the free exercise of religion under the First Amendment to use hallucinogenic drugs and drug peyote as part of their religious ceremonies. They brought the case up, simplifying the facts of it, but that's basically what they claim, that their religious desire to use peyote exempted them from the law of banning drugs. Justice Scalia wrote the opinion of the case, and he returned to the secular route, the one that Justice Frankfurter had used to deny relief to Jehovah's Witnesses. And Scalia said, conscientious scruples have not, in the course of the long struggle for religious toleration, relieved the individual from obedience to a general law not aimed at the promotion or restriction of religious belief. If it's a valid law, if it's fair, if it's neutral, if it's not going to view you or anybody else, forget it. You needn't be arguing that you are covered by the First Amendment, the free exercise of your religion exempts from the law. You're not. And again, he repeated the idea. He said, it just can't be. If people can pick and choose which laws they want to obey based on their consciences, we're going to have chaos. Right? So he said that. So this declaration led to immense controversy because it overturned the existing practice on the court, which said that yes, you could be justified under the law unless the government had a compelling interest to the contrary. So if the government had no compelling interest in the law and you had an objection in conscience, you could be exempted. But Scalia went back to the secular route. Now, it was valid in his case because whereas the court had said in the Jehovah's Witness case, it's not a valid secular law, it's imposing a belief. In the peyote case, it was perfectly legal because the government obviously has power to ban hallucinogenic drugs. So there was no question that it wasn't a valid secular law. So now, we have two positions represented on the Supreme Court. The first says that if the law is valid, forget it. You're not exempted under the First Amendment. So Scalia, the court in Vietnam, disassociated conscience from religion. In the second case in 1990, Justice Scalia disassociated the First Amendment from freedom of conscience, what we call freedom of conscience. I'm describing this in terms of being exempt from particular laws. So now I'm going to give some comments on the present situation. Now, it's important to note here that Justice Scalia was not saying that a person could not be exempted from obeying a law. No, he's saying, yes, you can be exempted from obeying law. He said that if Oregon had passed a law, as other states have, exempting people for the use of peyote in religious ceremonies, that would have been fine. He wasn't contesting that. He was just saying, you cannot come to this court and say, the free exercise of religion on the First Amendment guarantees me an exemption from a law. You should say, no, it doesn't. Now, Thomas, he was saying according to the secular route. And I think that when we think about the First Amendment, the free exercise of religion, we tend, I'm not saying what we tend, but I'd say we tend to think that the free exercise of religion means I can follow my conscience. Would that be right? It isn't. It doesn't mean that. It doesn't say that citizens are given the right to follow their conscience. It says Congress shall make no law. It's not about what I do. It's about what the government, what the laws the government enact, and that has gotten confused. And Scalia very much returned to that. So I'll make some comments about this, and maybe this will surprise you to say that I tend to agree with Justice Scalia, and I think that his solution is the best solution for dealing with the rights of conscience. First, I think his decision keeps the government out of making religious decisions. And that's the purpose of the First Amendment, and we're all protected if the government is kept out of making religious decisions. But according to the rule about a government compelling interest, well, what happens there is that, well, the government takes the scales and they put your conscientious belief on this side, and they put the government compelling interest on the other, and they weigh them. And so if the government compelling interest outweighs your conscience, well, too bad. If it doesn't, fine. So that means that we can't pick and choose among the laws, but we're saying the government can pick and choose for us. I don't believe that's right. I don't believe we should give the government that. And secondly, as Scalia, sharp man, very worthwhile. It's worthwhile if you ever have an hour to read, very sharp and aggressive man. But he pointed out very practically. He said, "Look, you guys, the other guys on the Supreme, the other people in the Supreme Court, look, you guys are all making this big deal about you are in favor of the rights of conscience, and that you are going to give people exemptions because of if the government doesn't have a compelling interest." He says, "Look at your record. You've done virtually nothing. It's a useless rule." I'm putting words, it's fine. But he said, "It's not very good. You haven't done a darn thing. What have you done? You give it a couple of people who wouldn't work on Sunday. You gave them the right to workers' insurance. What do you get when you're fired from a job? Compensation, you don't work. You gave them the right to that." He said, "You didn't insult their job. You just gave them a little bit of insurance." Oh, what else you did? Well, you gave a woman who said that she couldn't put her picture on her driver's license in Nebraska. And you said, "Okay, that's all right. You can do that." Well, great. But I'm simplifying. There were other things to do, but for dramatic purpose, I'm simplifying. But look, so they gave a woman the right of conscience because she couldn't put her picture on the driver's license. I mean, how many of you don't want to have your pictures on your driver's license? How many people are going to go around without picture ID so that they can't ever get on a plane, cash a check, or basically do anything? I mean, what he was saying was, look, you're making a big deal about this government compelling interest, but in actual fact, it led to very little relief for people, and I think he was right. Because the great issues facing us, as the Manhattan Declaration says, will deal with claims of conscience regarding abortion, the performance of certain medical procedures, the performance of same-sex marriages, and I very much doubt that the courts, under the compelling interest rule, would give much relief to those. The courts have never given much relief to the major religions. In terms of what they make a big deal about as religious liberty, the Supreme Court has always favored, what do you call it, eccentric, I'm not going to say crazy, but eccentric, romantic, what they think is romantic small groups who object and who are being overwhelmed by the society. Sometimes they were, sometimes they weren't. But basically, I doubt very much that under the compelling interest rule, they would give Catholics, Catholic hospitals, Catholic doctors very much relief. They don't tend to sympathize with members of the great and the large and pure and popular religions because they don't need protection. And of course they do. And then thirdly, of course, I'm talking about, so should claims of conscience be exempt from laws come under the First Amendment? Thirdly is that now that they have disassociated conscience from religion, and the First Amendment deals really only with religion, then it wouldn't cover people who are conscientious but who don't want to perform abortions. And there are people who are non-religious, who are atheists, who do not want to perform abortions. And we should protect them too, and we should encourage them and join with them and encourage more people. So if conscience is disassociated from the First Amendment then could the doctor who was an agnostic claim, well, under my conscience, well, yes, I think he should, but could he do it under the First Religion, under the First Amendment? Well, if the First Amendment is about the free exercise of religion, you got a conflict. You have to extend it very much and more so than it needs. So I tend to see Justice Scalia as the best way of protecting religion, because it gets the government out of religion, and the purpose of the First Amendment is to get government out of religion. The whole idea was to leave religion alone, that a religion would prosper, that the First Amendment said the government has this amount of power. Outside of that, you have society and religion. If religion wants to prosper, it would prosper on the basis of the people who believe it. If it doesn't prosper, it won't prosper because people don't believe it. It worked immensely well in America. We should try and keep the government out of our religion insofar as we can. And one of the problems in dealing with exemptions and with religious freedom is the enormous increase in the reach of government. And now we tend to think that the free exercise of religion or the rights of conscience is a gift of government. It is not a gift of government. In the American constitutional system, freedom of religion comes from the absence of government, not from the presence of government. People say to me it's the part of government to protect small and vulnerable groups. No, it isn't. It is the purpose of the government to keep out of the business of religion, and if the government has no power or jurisdiction in religion, it cannot establish religion, it cannot impose religious doctrines or religious beliefs on people. It cannot do. Now, it can impose laws that I determine affect my religion, and that's going to be a big issue, but I don't think that we can get to there if we don't realize that we need to get the government out of religion. And if we don't go back to a sense of a more limited government, we can't reverse all things that have changed. But the idea that the government has no power in religious matters is still very true, and it is still very much the law of the land. But it has been obscured because the court itself has come to think of itself as the defender of religious liberty. The First Amendment was enacted to defend us from the court and from the legislatures and from the government. They are not our protectors. They are the ones that the First Amendment protects us against. That has very much been lost. And it is lost because we have internalized, and the courts have helped us to do this, that, well, the government is our protector. No, it isn't. Our protection comes from keeping the government away, and the very language used sometimes, that the scholars and jurists and judges talking about accommodating religion. The government is not supposed to accommodate our religion. The government is supposed to keep out of our religion. But you see how it has changed. Before the First Amendment was passed, there was a great deal of religious liberty in America. I mean, we shouldn't think that the First Amendment came and that there was religious freedom and there was persecution and torture. No, there wasn't. The First Amendment actually didn't affect anybody's life at the time. First of all, because it only applied to the federal government. And secondly, because the states took care of religious things, and there was a great deal of religious liberty for 100 years before the First Amendment was passed. Because in 1689, the English government passed the Act of Toleration. That was tolerating people who descended from the Church of England, if you were Protestant, not Catholic or not Christian. But since most of 99% of the people in America at the time of the Revolution were Protestant, they enjoyed a great deal of liberty. But what kind of liberty did they enjoy? They enjoyed the liberty of toleration, a grant from the government. The government granted them toleration. The government said, no, we have power over religion. We have power to establish a church. We would make you conform to that church if we wanted to, but we won't. We will give you toleration. And we will accommodate you. James Madison came along and he changed the Virginia Declaration of Rights in 1776 to change it from the fullest toleration of religion to the free exercise of religion. What was the difference?